Hi everyone. So today's module is 3.27, the English legal system, and we're going to be looking at the assignment discussion today. So we've done learning outcome 1, 2, 3 and 4, and we'll be looking at the assignment discussion. But before I go into the assignment discussion, I'm going to look at the learning outcomes briefly, so that you have an idea of when we go into the assignment session, which areas to cover in which learning outcome. So this is a quick summary of each learning outcome. So we'll go through firstly with learning outcome 1. And in this learning outcome, we looked at understanding the key principles of English law. So we looked at the different methods by which laws are made. We differentiated between criminal and civil law, and we looked at differentiating between public and private law. So we looked at the different methods by which laws are made, and we looked at the different stages, both from the House of Commons side and also the House of Lords side, and we looked at how each bill is passed through each house, and then the final stage is the royal assent. So we looked at how a bill starts in the Commons. So first reading, we then went on to the second reading in the House of Commons, and this is where MPs want to debate the main principles and any sort of issues around the bill. We then went on to the committee stage, and this is a detailed examination of the bill. It starts with looking at the bill and any sort of proposals or changes that need to be made. We looked at the reporting stage, and this is any sort of further amendments in the House of Commons, and any suggestions from MPs. And then the third stage, and then we looked at the first reading from the House of Lords, so moving on to the House of Lords, and then the second reading from the House of Lords. And we looked at the committee stage in the House of Lords and the committee stage where the clause are agreed and voted on. We then went on to the reporting stage and amendment changes again in clauses. Third reading, and then continued with the third reading, and then consideration for any sort of amendments that need to be made. And that's in the third reading in both houses, House of Commons and House of Lords. And then we looked at the royal assent. So when a bill has been completed by all the parliamentary stages in both the House of Commons and House of Lords, it must have royal assent, and that's the only way it can become an act of parliament, so it could become a law, and that would be through the monarch, in this case the king, to make the bill formal and announce it in the houses. So this then we just went on, looked at how it starts and the steps: first reading, second reading, committee stage, report stage, third reading, and then Commons, first reading, second reading, committee stage, report stage, third reading, consideration of amendments from both houses, and then royal assent. We then went on to, in learning outcome 1, to look at 1.2, which was differentiate between criminal and civil law. So the difference between each one, and civil law ensures that that individuals are protected from one another and the state. We gave some examples that fall in both criminal and civil law. We looked at considerations made by courts in civil law cases and the penalties and remedies available. And in most civil cases, the remedy available is in a form of damages or compensation or any sort of orders. Then we went on to look at criminal cases, and that is there to ensure that the UK individuals are abiding by acceptable behaviour and the law. And if breached, it's a criminal offence and it's prosecution. So it could either be, custodial sentence, it could be community order, penalties, any sort of imprisonment. And we looked at how a criminal law case is proceeded through the CPS, Crown Prosecution Service. We went on to look at the consideration, so that the individual must have had the mens res and the actus reus intention. We then went on to look at examples of criminal law cases, things like, murder, manslaughter. We had a comparison chart between civil law and criminal law, and looked at the comparison, the purpose, the jury opinion, who the case can be filed by, the decision and the standard of proof, the burden of proof, the type of punishment given. Examples like for civil cases could be disputes against landlord and tenant, divorce proceedings, whereas in criminal law it could be robbery, trafficking, murder, the appeals and the commencements of the proceedings. We then went on to look at 1.3, which was to differentiate between public and private law and what the difference is between each one. So public law administers the relationship between the government and individuals. It comprises of constitutional law, administrative law, and criminal law. We looked at the importance of this and the significance to ensure that the public interest of a general population is protected. And we also looked at how public bodies derive their legal authority. We looked at what are public wrongs, and remedies available under public law. We then went on to private law, and this is the body of law which governs the relationship between private individuals and their rights and obligation. Things like contract law, property, equity and trust, tort, family law, so we looked at that. And then we looked at the classification. So you've got law, public law, private or civil, and which fall within that. So you've got, within public law, you've got constitutional, administrative and criminal. Within private law, you've got contract, tort, property, tort and trusts, and the features of private law. We then went on to the remedies and sanctions under private law. So you could have, if someone's supplied some goods to you, you haven't received payment, you can return the goods, damages and compensation. We then went on to look at remedies and sanctions within private law. And things like pecuniary nature, remedy, compensation, breach of contract, and then the references for Learning Outcome 1 and some additional journals that are on Moodle for you to look at Learning Outcome 1. We then went on to Learning Outcome 2. So just a quick summary of what we did in Learning Outcome 2. Again, we looked at understanding the rules of statutory interpretation, explaining the traditional techniques of statutory interpretation and how they are used. And we looked at intrinsic and extrinsic aids as well that help judges with making decisions. So we looked at 2.1, explaining the traditional techniques of statutory interpretation and how they are used. And we looked at the importance of statute within making a decision and how judges are called upon to interpret the legislation. We looked at the rules of statutory interpretation, which are very important when it comes to making a decision in a case for judges. So the literal rule, the golden rule, the mischief rule, and the judge's discretion. So firstly, the literal rule is what the statute has given its ordinary meaning to, so its natural meaning. So, you know, it will be read as it is, and there's no further different meanings of it. We also looked at the importance of the Berryman case, 1946, in regards to the literal meaning. We then went on to the golden rule, and this is to kind of prevent any sort of absurdity or inconsistency when interpreting the Act, and it can be applied narrowly or widely, which it gives the discretion to the judges. And we looked at the case of Odler and George, and we Sigsworth, the defendant had murdered his mother, and how we could, there was a use of, if it was the use of literal rule, how he'd benefit. If the golden rule came into force, how he'd, it would be applied, and he would not inherit anything. But if it was the literal rule, it would be an unjust result. We then looked at the mischief rule and looked at the landmark case of Hayden's case in 1584, where the court actually identified 4 issues when interpreting statutes. We then went on to the judge's discretion as well, and that's really important because in regards to it provides judges with the ability to interpret legislation in the best way possible to achieve the best result for the individual. And in exercising the discretion, judges use, like we said, intrinsic and extrinsic aids, which is the next part. We looked at 2.2 to describe intrinsic and extrinsic aids. So extrinsic aids are matters which help put an act in context. Intrinsic aids are regarded as acceptable, so it could be the long and short title, it could be the preamble, it could be different definitions or sections, schedules and headings. Advantages, we looked at intrinsic aids, so it's more respectful of Parliament to look elsewhere in the Act rather than outside the Act. And the case that was mentioned for long title was the Cornwall, CC and Baker case. We also looked at intrinsic aid and we referred to some disadvantages as well of it. And the problems are with wording as well. And we looked at the case of Whiteley and Chappell, 1868. We then went on to extrinsic aids, and they are matters which help put an act into context. And these things are found outside of the actual statute, which may be considered by judges to help them understand the meaning of a statute more clearly. Because sometimes, you know, historically, the wording of a statute may have made sense, but in today's society, the wording may not make sense, but may not apply, but the meaning of the word may mean something else. So the following intrinsic aids have been regarded as acceptable. So we've got dictionaries and legal textbooks, other statutes, reports of the Law Commission and other law reform bodies, international treaties, so explanatory notes. And then we've got intrinsic aid sources such as dictionaries and legal textbooks. And dictionaries, as we mentioned, are the obvious tool to assist with the literal rule. Other statutes, so earlier acts that have relevance in tracing the mischief that an act was designed to tackle. We looked at reports of the Law Commission and other law reform bodies. An act is often preceded by investigation by one of the bodies set up by the government to investigate options for reforming the law. We then went on to look at international treaties and the impacts of that. So, you know, the way that it would be clear breach of treaty signed by United Kingdom's government. We also looked at explanatory notes. The acts passed since 1999 have been accompanied by explanatory notes, and these notes summarise the main provisions of the Act and explain the background to the Act. So that's really important. And the government department responsible for legislation writes them after the Act has been passed. And for this reason, they are regarded as intrinsic aids. Then we looked at some advantages of intrinsic aid and referred to the Cheeseman and Vaughan case, which is quite an important case. Also, the use of Hansard when clarifying what Parliament meant, as in Lord Denning in the Davies and Johnson case. and also looked at the Fothergill and Monarch Airline. We looked at some disadvantages of intrinsic aid, and the important case in regards to that was Pepper and Hart, and what the Minister said may not be clear in the Deegan case. Lord Bingham's ideology of this. There were some cases to research for you, and then we had a mind map here which identified what intrinsic aids are and what extrinsic aids are. So intrinsic aids, long short title of the Act, so it could be the Abortion Act, a preamble, and then the definitions, sections, schedules, and the punctuation. And then extrinsic aids could be Hansard, previous versions of Acts, Interpretation Act 1978, international treaties, textbooks, explanatory notes, dictionaries, and Hansard. So these are some of the references used for learning outcome 2. And now we're just going to go on to learning outcome 3. So after we've looked at learning outcome 1 and 2, we've now gone on to learning outcome 3 in regards to the English Legal System unit. And a summary of what we've done in learning outcome 3 is to know the organisation and work of the English courts. So we looked at the learning outcomes, which was to describe the court hierarchy for both criminal and civil law. We looked at explaining the process of appeals. We went on to look at 3.1 is describe the court hierarchy for both criminal and civil law. We looked at the hierarchy of the civil law. So we looked at the hierarchy of civil courts in the United Kingdom. So we have the Supreme Court of UK, the Court of Appeal, the High Court, and within the High Court, you've got the Queen's Bench Division, the Family Division, and the Chancery Division. We then went on to look at the county courts and the tribunals. So the Supreme Court of the UK, we looked at it being the most highest court in the UK, England, Wales, and Northern Ireland, and it's the final appeals court. Then we went on to look at the Court of Appeal, 2 divisions within the Court of Appeal. We've got the criminal division and the civil division, and what they actually do as well. We then went on to the High Court and identified that there were 3 divisions within the High Court. So you've got the Queen's Bench Division, deals with cases relating to contract, tort, and mercantile law, commercial law. Then the Family Division, which deals with all family cases. The Chancery Division deals with companies and divisional and patents. And then the decisions of the High Court can be appealed to Civil Division of the Court of Appeal. We then went on to county courts and identified that there are about 92 courts within the towns and cities in England and Wales. And they handle most majority of litigations and cases related to civil cases. And then we went on to tribunals, and there are specialist tribunals, areas of law such as immigration, education, employment, child welfare, which are governed by tribunals, individuals, and they're separate areas for all across the UK. So you could, if you have a dispute at work, there's an employment tribunal. Any forms of discrimination, any sort of education issues, you'd have an education tribunal, and then any sort of issues in child welfare would be dealt with a welfare tribunal. So these are all separate within the UK, and they are dealt with separately. So now we're going to go on to look at the hierarchy of criminal law. So you've got the Supreme Court at the top, and then you've got the Divisional Court, the Queen's Bench, and then you've got the Magistrates Court, the Court of Appeal, and the Crown Court. So the Supreme Court is headed by the Lords of Appeal or Law Lords. The Divisional Court is Lord Chief Justice and judges of the Queen's Bench. The Court of Appeal is Lord Chief Justice, Lord Justice of Appeal, and High Court judges. And then the Crown Court is Queen's Bench and Circuit judges, recorders, and justices of the peace. And the Magistrates Court is justices of the peace and district judges. So, hierarchy of the criminal court within the Supreme Court is the final court of appeal. And the Supreme Court hears matters on points of law and public importance for the whole of UK. The Court of Appeal constitutes the most senior courts of England and Wales, divided into two divisions, as we mentioned earlier, civil and criminal division. And then we looked at the Crown Court, who sits in centres around England and Wales and deals with indictable offences that are transferred from the Magistrates Court, including serious criminal cases, such as maybe things like murder, high traffic cases, fraud, trafficking. So because the Magistrates Court can't deal with them, they are referred to the Crown Court for trial by jury. You have the Magistrates Court, and this is the first court of instance that hears all the cases. Up to 95% of cases are dealt with at the Magistrates Court, and they deal with summary either way offences or indictable offences. And they are referred, indictable ones are referred to the Crown Court, as the Magistrates Court do not have the jurisdiction to deal with them. And cases that would be dealt with by the Magistrates Court are things like, traffic offences, minor traffic offences, minor theft, like maybe pinching a packet of crisps or a bar of chocolate from a shop. So it's really minor offences, less serious offences. If they cannot be dealt with by magistrates, they would either go to the Crown Court, where a judge and a jury would deal with this case. So 3.2, explain the process of appeals. So appeals process in the Court of Appeal is most cases permission to the Court of Appeal is required. Once they've lodged the appellant's notice within 21 days of the decision to be appealed with grounds of appeal. So there must be grounds of appeal to identify that they have the right of appeal. And full documentation of the skeleton argument needs to be in support of that. Usually no new evidence is allowed, but sometimes it's possible if they file a fresh evidence. In the Supreme Court of UK, an appeals committee of 3 Supreme Court justices will decide whether to grant an appeal or not, based on the evidence and based on, points of law. These are the references for Learning Outcome 3, which we looked at the hierarchy of the courts, the importance of the courts within the UK, and both the criminal and civil division, and the highest court within the UK, which is the Supreme Court, and their powers, going down to the Court of Appeal, the High Court with its 3 divisions, and then also looking at the county courts, the tribunals. We also looked at the Magistrates Court and the Crown Court, and what kind of cases are dealt with each. So quickly, I've just gone through Learning Outcome 3. Next one is Learning Outcome 4. These all have been done individually. So Learning Outcome 1, 2, 3, and 4 that have been recorded for your benefit. Thank you. So now the final learning outcome, which I'm going to quickly go through before we go to the assignment session, is learning outcome 4, which is to understand the operation of judicial precedent and the importance of this within making a decision in a case. So the learning outcome here is to explain how the rules of stare decisis, ratio decidendi, and obiter dicta are used. Differentiate between distinguishing, reversing, binding, and overruling, giving examples of how they are used in specific cases. and describe how courts are bound by each other with reference to the case of Young and Bristol Aeroplane Company Limited, 1944, and explain the impact of res judicata. (4.1) Explain how the rules of stare decisis, ratio descendi, and obiter dicta are used. So we looked at what stare decisis means, and it means in Latin to stand by things decided. And the principle that a court should follow precedent established by previous cases with similar facts and issues to provide certainty and consistency. And generally there are two types of precedent: binding precedent and persuasive precedent, which we went through. Ratio decidendi is the rationale for the decision and the principle of law on which a decision is based. We looked at how to find ratio decidendi, so how to look at your subject outline, also reading list or case list, to read the head note as well, because that's really important because it highlights the key issues or legal principles considered by the case, so they need to be looked at. Also, to read the whole case is important towards, rather than end of the judgment, but unfortunately you can't just skip to the end. You need to read the whole case because it identifies legal principles, outlines the facts of the case and the legal arguments presented to the court before they made this decision. So it's essential to read the full facts of the case. Focus on the key facts. So focus your attention on the precedents or legal principles, because the court discusses at length the facts of the case where the judges emphasize this. How to find ratio decidendi. Obviously, the aha moment, so where the court reached a particular decision. Dealing with multiple judgments as well. This is really important in regards to that. And don't panic towards the end if you can't find the ratio. Obiter dicta we looked at. It refers to a judge's comments or observation in passing on a matter arising in a case before him, which does not require a decision. So it's really important that you look at obiter in regards to that. Obiter remarks are not essential to a decision and do not create binding precedent. However, obiter remarks of senior judges, for example, may be indirectly instructive or persuasive. The use of obiter dicta. In reaching decisions, courts sometimes quote passages of obiter dicta found in the text of the opinions from prior cases. The quote passage of obiter may become part of a holding or ruling in a subsequent case. Then we looked at 4.2 and we looked at differentiating between distinguishing, reversing, binding, and overruling, giving examples of how they've been used in specific cases. So we looked at what distinguishing is, and this is the method that can be used by a judge to avoid following a past decision where he would have otherwise have to follow. And we looked at in this instance, we looked at the facts in the case of Balfour and Balfour 1919 and Merritt, and how there was a distinction because in one of the cases they were married and in the other case they were separated. So we looked at how they would draw the distinction from them cases. We then went on to reversing, and this is where the court higher up in the hierarchy overturns the decision of the lower court on appeal in the same case. And we looked at the Court of Appeal. In this case, an example would be may disagree with the legal ruling of the High Court and come to a different view of the law. And in this situation, reverse the decision made by the High Court. We then looked at binding, and this is a binding precedent, is a decided case which a court must follow by law. And this is legal principles of the case, facts of the case are the same, and then they must be followed by law. Also, we looked at the precedent is binding or persuasive, and the judge would consider these factors, so the material facts of the case, the hierarchy of the courts, and also the ratio distendi and obiter dicta, as we've discussed before. We looked at overruling is where a court in a later case states that the legal rule decided in an earlier case is wrong. We gave examples of Pepper and Hart, 1983, a really important case, and Davies and Johnson, 1979. We then went on to 4.3 and looked at how courts are bound by each other with reference to the Young and Bristol Aeroplane Company Limited, 1944 case. We looked at the principles that were adopted in this case. So there were three main principles adopted, and we looked at the importance of this case in regards to the decision making. We then went on to 4.4. We looked at the impact of res judicata, what the definition of it is within Spencer, Bowie and Hadley, 2009. Then we went on to the significance of res judicata with reference to the Henderson and Henderson case. And it is a doctrine to prevent a party from relitigating. We then went on to the principles in regard to Virgin Atlantic Airways and Zodiac Seats UK Limited by Lord Sumption, who identifies 6 principles in this case, and the importance of these principles in regards to making up the doctrine of res judicata. So we went through the 6 principles, and then we finished off learning outcome 4, and these are the references that have been used for learning outcome 4. So I've gone through learning outcome 1, 2, and 3, and 4 and summarized them. I've done the learning outcomes individually, which I recorded for your benefit. And now I'm going to go on to the assignment session. So when you're doing this assignment, you need to make sure that you are following the guidelines for doing this assignment, and they would be things like make sure you are using Harvard referencing system, make sure you are you have your name on the front cover, the unit title, which is Unit 327, the English legal system, and make sure you have your the credits of the unit, and also the awarding body, which in this case is ATHE, Level 3 Diploma in Law. You could have a contents page when you start doing the assignment to identify what part of the assignment you're doing, and make sure that you've got headings for each element, and do not change the wording of the tasks that are set for you, and make sure you are using Harvard references. So let's go through the assignment and what the expectation is for this assignment. So as we mentioned, it's Unit 3.27, the English legal system, Level 3, 15 credits, and the qualifications is ATHE, Level 3 Diploma in Law, QCF. So this is the scenarios you have to deal with. This case to do with some tasks to do. So you have gained work as a paralegal in a national law firm. As part of their corporate social responsibility CSR program, the organisation is very active in the local community. As part of your induction to the organisation, you have been asked to help out at a local school. You have been given 2 areas of work. One involves the careers guidance in school, which is very keen to improve the advice and guidance for young people hoping to enter the legal profession. The Careers Centre manager plans to update all their materials, as well as run a series of workshops titled Introduction to Law. You have been asked to prepare materials for him. You will produce presentation materials, supporting notes and handouts. The second area of work involves the student support team. 2 young people come to them if they are worried about getting into trouble with the law. The team need some background information to help them answer the questions which are asked by the young people. So these are the tasks that need to be done for this case study, okay? So task 1, key principles of English law. So the Careers Centre has asked for a PowerPoint presentation, so you need to, with a separate notes, which will help students to understand some of the important topics they would learn if they choose to study law. Now you should, for task 1, firstly, explain the different methods by which laws are made. Make sure you include statutes, case law, and EU law. So this would be your first heading, as I've highlighted there. And that would be your heading. So do not change the wording of that. So that's task 1, and there's 3 parts to it in the past element, okay? So explain the different methods by which laws are made. Make sure you include statutes, case law, and EU law. The second part of task 1 is to differentiate between criminal and civil law. Make sure you have these as headings so that the person who is marking the work, the assessor, is able to identify that you've completed these tasks. In the third element, third part of task 1, you need to differentiate between public law and private law. Again, making sure that you are identifying the difference between each, and make sure that you have got this as a heading. Now, if you want to do extension activities to gain a merit, okay, you would have to complete this task, which is to explain the process by which a bill becomes legislation. And that will be looking at the process that we talked about in regards to the first reading, the second reading, the third reading, the committee stage, the report stage, from the House of Lords and House of Commons, and how it has to go through both houses before it becomes an Act of Parliament, and then it needs to, the final stage is royal assent. So you need to be able to explain the process by which a bill becomes legislation, so becomes an Act of Parliament, and that would gain you a merit. So you need to make sure, if you want to do that extension activity, you need to highlight that this is the extension activity and it is to gain a merit, okay? So, and that would be in Learning Outcome 1, AC 1.1, 1.2, and 1.3. Okay, so that is all of task 1. Make sure you have got headings for each element of each task. Then you've got task 2. Okay, students need to understand some of the detail which is required by legal professionals. So produce 2 information sheets for distribution at the workshop. This is task 2. So which in task 2, part 1, you need to look at explaining the traditional techniques of statutory interpretation and how they are used. So here you will look at what statutory interpretation and the rules and the techniques that are used, okay? You need to make sure you have that as a heading, and this is for the past element. The next element is part 2 of task 2, is to describe intrinsic and extrinsic aids with reference to examples, but also this is another heading for the past element, okay? Now, if you want to gain a merit, you would do the extension activity, okay? So extension activity, to gain a merit grade, you must include the following in the information sheet. You must look at an explanation of how intrinsic and extrinsic aids are used by courts as an aid to statutory interpretation. And you must highlight that this is the merit grade. So if you've done the top 2 for pass, this is to gain a merit, okay? So you must highlight that you have completed this to gain a merit grade, okay? Now, in task 2, if you want to gain a distinction grade, you must also include in information sheet 1, because you are producing 2 information sheets, an analysis of how the techniques of statutory interpretation have been used in a specific case law. So you need to identify that in information sheet 1 to gain a distinction mark. So it needs to be really clear where you are gaining a merit mark, and then it needs to be clear where you are gaining a distinction mark, okay? And you need to highlight this with the heading to identify that you've gained merit or distinction for the task 2, which is on statutory interpretation. And that is LO2, AC 2.1 and 2.2. Now for task 3, okay, you need to support materials on English course. So task 3 is where the school is building up materials for the library on careers in law, okay? Here, the school librarian has asked you to prepare information which he can put on the school intranet, in which you would need to, for the past elements, you need to describe the court hierarchy for both criminal and civil law. So you need to make sure you have that as a heading. Describe the court hierarchy for both criminal and civil law. And then for the second part of the pass criteria, with the heading, you need to explain the process of appeals. Now, this is for the pass criteria for task 3. Now, if you want to gain do the extension activities and gain a merit, you must also, so this is to gain a merit. If you want to gain a merit, you must also look at explaining the types of cases heard at each level in the court hierarchy and the powers of the different courts. So things like, you know, if you're talking about the magistrates' court, what kind of cases are dealt with there? Things like petty crime, you know, motor crimes, petty motor crimes, the Crown Court, murder, manslaughter. So these are things that you would need to identify to gain the merit grade. Okay, so that's the extension activities. Now, if you want to gain the distinction grade, okay, you would need to explain the relationship between the English law and European Union law, okay? And this would be trying to identify what the relationship is between the English law and the European Union law, and this is to gain a distinction mark. And these will be all LO3, AC 3.1 and 3.2. So that's to gain the distinction. Now, it's really, really important that you make sure that you are putting the headings for everything, okay? Then we have task 4. And this looks at the operation of judicial precedent. So the student support manager has often been asked about the details of the court hierarchy and how they work. He knows that judicial precedent is critical and involves the application of several principles. However, he has asked you to outline these. He's asked you to produce detailed notes for him, which he can use to support young people. And these notes should include, and that is task 4, and this is for a pass criteria, there's 4 elements. So firstly, you need to, the notes should include explaining how the rules of stare decisis, ratio decidendi, and obiter dicta are used. So you need to explain that and have that as a heading. Do not, again, I will reiterate this again each time I'm going through, do not change the wording of the tasks, okay? Secondly, you need to differentiate between distinguishing, reversing, binding, and overruling, giving examples of how they're used in specific cases. So the cases we've looked at in regards to distinguishing, reversing, binding, and overruling, use them cases to help you support, identify, and differentiating between them. Okay, and these cases are on the slides as well. Thirdly, you need to describe how courts are bound by each other. with reference to the case of Young against Bristol Aeroplane Company Limited, 1944 to all ER 293. So you need to look at that case and you need to describe how the courts are bound by each other and use that case to help you, to support you. You could use LexisNexis for the case. You would have identification of the case on Moodle, additional resources. So you could use that case to look at how the courts are bound by judicial precedent. Okay. Then that is for the third part for the pass criteria for task 4. Then if you want to, the fourth criteria for the pass criteria is to explain the impact of res judicata. And that is the heading that you would put in and then look at the impact of res judicata and what it is, okay? So these 4 are part of the pass criteria for task 4, which is the operation of judicial precedent. Now, if you want to gain a merit and do the extension activities, you would need to also, your notes must also include explaining the impact of the use of distinguishing, reversing, binding, and overruling in specific cases. Okay, that would be your heading, and that would be to achieve a merit criteria. Okay, so you'd have to do that extension activity to achieve the merit criteria. You need to look at explaining the impact of the use of distinguishing, reversing, binding, and overruling in specific cases. So you need to look at cases. And that is learning outcome AC 4.1, 4.2, 4.3, and 4.4. These are some guidelines for assessors that you could refer to in regards to any sort of information that is needed in each task. So if you look at task 1, the learning outcome AC 1.1, 1.2, 1.3, the methods by which laws are made, explain that in detail, and examples should be provided. The differentiation between criminal and civil, comparison, and types of offences covered. The learner must provide detailed explanation of the process by which a bill becomes legislation, included with examples of all stages. Examples of cases to support your differentiation between criminal and civil law. And then differentiating between public and private will include its effect. So task 2, the learners will include a full explanation of the techniques of statutory interpretation and used by courts. When describing in task 2 intrinsic and extrinsic aids, the learner must demonstrate their knowledge and understanding of long, short titles, punctuation and definition sections, and dictionaries and sources, and identify main points clearly where they are important. Where you are asked to include cases and examples, please make sure you're using them either for task 1, 2, 3, or 4, because it identifies that you are able to understand what the tasks are asking. Do not, again, I'll reiterate this again, and it's probably the last time I'll reiterate it, do not change the wording of the tasks when you are putting them as headings. Put what is required of you in the assignment. Task 3, learning outcome AC 3.1, 3.2. The information for the school intranet will be clear and include diagrams. So the court hierarchy and will include both criminal and civil law, and the explanation of the courts will be included. The appeals process also reference both to civil and criminal law, included different roles, Court of Appeal, Supreme Court, and the European Court. Using a number of actual cases as examples, learners will explain the types of cases heard at each level and the hierarchy. So they must demonstrate that they have a knowledge of powers of different courts, but also the relationship between English law and European law. Now, in learning task 3, learning outcome 4, AC 4.1, 4.2, 4.3 and 4.4, learners will use case law to indicate how they've been used. Also, the learner must be clear in describing relevant information. The rules will include all these listed. Examples of their use in specific cases will be the differentiating between distinguishing, reversing, binding, and overruling, and the impact of the use of distinguishing, reversing, binding cases will be explained. So learners must demonstrate they understand how courts operate, that they are bound, so the impact of res judicata, and also need to look at cases. So this is the full session for a summary of all the learning outcomes and a discussion of the assignment in regards to the learning outcomes. Make sure, again, and I'll reiterate this finally, make sure your name's on there, make sure your qualifications on there, make sure that you have put the unit, which is English legal systems. Make sure you are identifying if it's task 1, 2, 3, or 4, and make sure within them tasks you are identifying which elements you are doing. So if you are doing the extension activities, identify you are doing the merit activities and identify it clearly with headings. Do not change the wording of the assignments, and make sure that you are underlining and highlighting each element. So if you're doing the past, make sure you're doing that. And if you're doing the merit extensions of task 1, make sure you identify that. Task 2, if you're doing the extensions, identify that. And task 3, 4, same for all of them. Make sure you're using Harvard referencing throughout, and make sure you are referencing everything properly. If you have any questions, you could email learnerwork@ukvarsity.co.uk, and submission of the assessment is on ukvarsity.co.uk. Thank you for attending the session. And if you have any questions, please email ukvarsity learnerworks@ukvarsity.co.uk, and please use the additional sources on Moodle to help you complete the assignment. Thank you for attending today's session. Thank you.